Right. So I will be going to the judgment of the Supreme Court in 2021 about whether or not the EC can correct errors or mistakes. There are those who argue that you cannot say doing a re-collation is intended for a correction, an administrative purpose. And the lawyers for the NDC who were in court insist on that it is not something you can call a correction being done. So I'll reserve Clara for the attitude she will bring to this. Let's go to Ni Ama Ayikoi Otoo, former Attorney General. Thank you very much, sir, for joining us. What do you make of the Supreme Court's decision yesterday? Please unmute your mic.
Okay, thank you. Yeah, I have done that.
Great. We can hear you now.
Can you hear me now?
Clearly, sir.
Yeah, thank you. Thank you for having me. Well, the Supreme Court dealt with procedural matters. I had made the point that one of the grounds of quashing decisions is the breach of the rules of natural justice. And it's a very strong ground anytime it is used.
That's right.
I do recall when I did the case for Dr. Pakwesi Indum when he was disqualified. And it was one of the grounds I used, and he prevailed. So immediately I saw this one, I said to myself, wow, what is happening to this judge? Because if you don't give them a hearing, they will rush to the Supreme Court and tell the whole world that they were denied their right to be heard, which is also a breach of the rules of natural justice, and your ruling would just not stand. Again, I even have a difficulty with the NPP lawyers who went to court, because we all know that they are interested parties in the matter. And usually when you have a title, the Republic versus so and so, ex parte, the applicants, then you add what we call the interested parties. So if clearly there were interested parties, why did you leave them out? Again, when the guys went to court to say that, look, although we've not been served, we've heard of what is happening. So we have applied to be joined to the action. The judge did not grant that application. But if you look at the 55 Rule 6.1, the court may, on the hearing of an application for judicial review, allow a person who desires to oppose the application to be heard, notwithstanding that the person has not been served with notice of the application, and may direct that person to file an affidavit. So is the judge saying that he is so unfamiliar with this regulation, especially having regard to the fact that the right to be heard is so sanctified, so held sacrosanct, that if you breach it, you are going to run into difficulty. So all that the Supreme Court has done, in my view, is to say that because the people were not giving any hearing, well, we are going to quash the decision you make, but then the Mandamus is still alive, and you can go back to continue with your hearing. At this stage, that the NDC will now be, or the affected parties will now be given the right to be heard by filing their necessary affidavits. They've been given 2 days to file, whatever it is, for the others to also respond, and they have breached time for the hearing by 31st. So the Supreme Court did not decide on the merits. The thing with the Nsawam Ajiri and Afuano is a little problematic, in a sense that what they are saying is that the thing took place and it was concluded. So that ends the matter. But it seems to me that the main point they were trying to make is that there was no objection from the NDC itself on those two main issues.
That's correct.
They didn't think that anything arises for discussion. So no party really has won anything. You are going to start all over again. If you want me to stop here, fine. Otherwise, I've listened to the rest and I can continue to make more inputs.
Right. So, and let me quickly bring this so that we don't go too far. When the issues of corrected figures for the presidential election came up in 2021 in the Supreme Court held and relying on Article 297 said that where a power is given to a person or authority to do or enforce the doing of an act or a thing, all such powers shall be deemed to also be given as are necessary to enable that person or authority to do or enforce the doing of the act or thing. So to that effect, they held that for the EC to have detected an error and to proceed to correct that error, there was nothing wrong with it. It has also been argued on behalf of the petitioner that the chairperson of the first respondent could not have on her own corrected the error she made without consulting the stakeholders of the 2020 presidential election. The court said no statute or regulation was cited to us by counsel for the petitioner for this submission, and our collective industry has not revealed any. This submission does not find favor with the court in view of Article 297 of the Constitution.
The implied powers.
So the court held that what happened was an error and the EC can correct an error. Now, so the matter that is coming up now is that what do you make of the point that first you fault the lawyers for not having themselves included the NDC or the affected parties before the High Court? But yes, what do you make of the claim that the EC had not refused to perform its official duty and therefore there cannot be a mandamus because it had not refused?
Well, I disagree with what Oliver is saying. I had the opportunity to handle a matter, the Republic versus the National House of Chiefs, Kumasi, expert in Nila Abimensa and others, where there was no prior demand and no refusal, but a mandamus was granted. I made it my prime point in going to the court to have these things quashed. The Supreme Court said no, in view of Article 23, which seems to have imposed a duty on all administrative powers, bodies, to adhere to their own rules. When you do not follow the rules, it gives the person who is affected a right to come to court and to seek redress. So as far as they are concerned, in view of Article 23, even when the person did not request and there was no refusal, what the court did was okay. So I will remind counsel and others to look at that report, Republic versus the National House of Chiefs, Kumasi, expert in Nila Abimensa and others, 2011. That is what the Supreme Court said. There's so much a responsibility on you to go according to the rules that or the laws that set you up, and you cannot do what you like and claim that somebody must have to make a request first. That even if no request was made, even if no refusal, you still are under a duty to perform. And so they went ahead and upheld what the High Court judge did.
We are familiar with the expert Alhaji Collins Dauda case, in which the courts effectively said that in a parliamentary election where the electoral process have been substantively carried out up to the point where a candidate has been declared elected, then, that will be valid and a petition can be brought to challenge that. So do you think in the circumstances, what the Supreme Court has done now, the status quo ante has not returned, so that in these 4 constituencies, these people are duly declared and the EC does not have the power to do a re-collation?
I do not agree with this issue, whether or not the EC has power to do re-collation. I don't agree with those who say the EC has no power. I'm looking at the constitutional provisions as against the CI 127, which is a subsidiary legislation. And looking at Article 45, it reads that the Electoral Commission shall have the following functions. C, to conduct and supervise all public elections and referenda. Now, at the end of Articles, the CI 127, you will find that it is the EC which must gazette the results and forward it to Parliament. We are not talking about any returning officer acting. We all know that the EC has a small number of permanent workers, and that around elections, what we do or what they do is to, employ or recruit a lot of, temporary workers. So this staff cannot be substituted for the EC itself, as if they are those who have the final say on the matter. They are supposed to work under the supervision. Even if you look at the regulations dealing with the returning officer, he works under the supervision of the district election officer. You see, so at the end of the day, everything comes back to the EC. And when you are suing, you don't sue any returning officer. You always sue the EC for something that you think has not been done. These are people who go to assist them. And so, in my view, so long as Article 45C has not been amended, that it is the Electoral Commission that shall, the functions include the conduct and supervision of all public elections. They have every right to look at it. They cannot sit down. We have all said that where there is fraud, it vitiates everything. Fraud is not different from dishonesty. We are told that the returning officer can only collect the results from all polling stations. We are being told that in most cases, all the results were not in. Under what circumstances did they declare the results? And you are saying that the EC should look on when it is his duty to organize these elections, and these are people who are only supposed to help. And between me and you, we know that when it comes to the recruitment, there are all sorts of things that take place in the recruitment. And so there are some who are there who are not necessarily going to do the work for Ghana, but to try and assist other people. You know that as a fact. But they cannot sit down and look on when some of these things are happening. Over 31 polling station results have not been collected, and you say somebody has been declared. The circumstances where you allow that is where you are saying that, even if we, in view of the unassailable, lead that the person has, even if you add all those that we have not counted, it will still not make any difference. So let it go on without it. But you are talking about 31. When we know of MP3, somebody winning with only 3 votes and the rest, and you are saying the EC must accept it. So, I think the Constitution should override the CI 127.
Yes, so the question will be, the court will determine what constitutes an error for which the constitutional provision you are referring to will apply. The substantive question is this, I think, and that's what is bringing up all of these debate, that you mentioned fraud. Fraud destroys everything. So who determines that there's been fraud? And that fraud destroys the outcome of anything. And what then do you make of the substantive law, the representation of the people law, section 20, which says that if there is intimidation, if there is non-compliance with law or the regulations concerning the electoral process, that has to be determined by a high court.
Well, I don't know about that, but also remember that under Article 46, the EC should not be directed in the performance of his duties, although that does not immune it from court processes. So where there are court processes, fine, but the independence, in my view, of the NDC, of the EC, gives them that authority to act when they feel something is not being done properly. And I'm still talking about Constitution, not the PNDC law.
Okay. Now, those results that have already been gazetted, and yet the Supreme Court says those have been quashed, what happens? Example where people suggest that the NPP could simply say, well, we are not pursuing the Mandamus application in the High Court anymore. After all, these have been gazetted. What do you think? How will it play up?
I don't know what the NPP or those persons affected would gain by saying that they are withdrawing, because there is so much left to be done, and it's only fair that they should go ahead and get the results collated. My brother was talking about Zamsugu. Is it different from what has happened now in Abekuma North, where the ballot boxes and all the pink sheets or whatever you call them have been bent? Should we go ahead and accept whatever results they have, declared when such things have happened? So please, me, as far as I'm concerned, the Constitution is supreme.
All right.
If what they have gone to, if they did anything wrong, because we all know that when cases are pending in court, you are not to interfere, then of course, what they have done will not wash. And I don't know who advised them to go ahead to do what they did. So I agree with Baka that those things, do not go anywhere. But whoever would advise them to go and withdraw the case in court would rather be doing more harm than good.
Okay, thank you. Now,